Okay, hopefully you can hear us now. We're going to start from the front. If you haven't heard, I said hello, and we hear Paul about the court case today. Paul, can you start from the front?
Hi guys, sorry, I hope the sound's coming. The sound's fixed now.
We did this in 15 minutes, so...
Yeah, so this is a bit of a rush. So today we were in the South Gauteng High Court with the licensed declarator case. Again, we had to re-enroll it. We were number 57 on the roll, so we didn't expect to get heard this morning, even early this afternoon. So we were preparing to go to rush through to court a little bit later today. But so from position 57 on the starting grid, apparently we were jumped to number 1.
Are you serious? Number 1?
The judge,
wow.
The judge was a very senior judge. Instead of having a learner judge like last time, this time we had Judge T.P. Mudau, who's been an acting judge on the Constitutional Court before and an acting judge on the Supreme Court of Appeal. So a very senior character. And so when we got to court, the state had not yet filed their answering affidavit, typically, but the state's attorney and the counsel, the counsel that was appointed by the state to speak for them, are also very senior people and very well versed in what we're talking about. So when the matter was called, the advocate for the state begged the court's indulgence for a further postponement to allow the state time yet again to file their answering affidavit, which is typical. Judge Mudau reluctantly agreed, stressing the fact that this matter has far-reaching implications and may even reach the Constitutional Court.
That's big.
For this reason, the matter was postponed and the state was ordered to file their answering papers, and a costs order was given to us. So we got costs already. Then the counsel for the state, in other words the opposition, and the state's attorney came to us and proposed that we go into a Rule 41A process according to the Uniform Rules of Court, and the lawyers that are listening to this will understand what this is, and this will be hashed out over the next week, I suppose. This is a court-ordered mediation process, which is impartial and independent. A retired judge sits on this generally, and he assists the parties to reach to resolve a dispute or identify the issues upon which an agreement can be reached. But remember, this is court-ordered, and it's also immediate. It has to happen within 20 days. So it's not something that they can kick down the road for a while. It's
for like 6 or 8 or whatever.
Yes, it has to happen this month still. Okay? And if an agreement can be reached, it becomes an order of, we take it back to the court, and the court makes that the mediation result an order of court. And it's an agreed order of court, which means that nobody, not the state, not anybody, can appeal it later or try to take it further, because it's an agreed, they've agreed to this mediation process. It's done. So that's quite exciting. So for the first time, we had a really senior judge on the bench listening to us right up front, and a senior state attorney and a senior advocate for acting the counsel for the state, all agreeing that this matter has to be decided. It's of national importance. This will, at the very least, allow us to talk to SAPS or to the state advocate who represents SAPS to find a way forward. This is, you know, if we had have got an order today, the court, the state would probably have challenged it. And then it gets kicked into the appeals process and blah, blah, blah. Then they allege that there's constitutional ramifications, and bang, we end up in a next year we're still waiting for an answer. So this is quite an inventive way of sorting this problem out.
And also looking at practicalities, how it's going to be done.
Looking at practicalities. So should this process fail, and as the judge made it clear that this is a constitutional issue, we will proceed with the Rule 16A notice for the lawyers amongst you, or the guys that want to go Google 16A. Such a notice requires a party raising a constitutional issue to prepare a notice, a Rule 16A notice. And it's a constitutional issue because this touches directly on the rule of law. This is the prime example of the failure of process. Because the fact that you can be granted a license, but you can't enjoy the fruits of the license.
And it's your property.
It's your property. It has huge ramifications. So we're hoping that this is going to reverberate far. So anyway, so this requires a party raising a constitution to prepare a notice, a Rule 16A notice, containing a clear and succinct description of the constitutional issue raised. The notice, after being approved by the registrar, must be posted by the registrar on a dedicated notice board in the relevant High Court. One of the main purposes of the Rule 16A notice is to inform anyone else who may be affected by this concept to step forward and become who may be interested in the constitutional challenge. So this is opening the door for all of the other associations, anybody impacted on this, to step into the process. So this could become a massive, massive issue. Something as large perhaps as the Department of Education issue, where the Constitutional Court found that you cannot have the right to education without the means to access that education. So this could become a monstrous constitutional issue in South Africa, and it will become that if we don't get this mediation, this court-ordered mediation packed away this month. So this will give us a direct route into the Constitutional Court, which is also quite important. And because they've recognized that this is a national issue, GOSA runs no risk in this process. So that's also important.
But thank you for everybody that actually supported
us in this. Guys, thank you so much for everybody that supported. We couldn't
have done it without the members.
This is the inflection point. This is the point at which we could perhaps, after seeing the success we had in the Constitutional Court as amicus with the fidelity matter, and what that produced with the directive for the expired licenses, on the heels of that, this could become our inflection point. It could be our way of turning this whole thing around.
And this is what GOSA is about.
This is what we've been about right from day one. This is what we've been working for. This is what we've been slaving for. This was the right case to bring at the right time. And perhaps when being booted out of court by the learned judge a couple of months ago was the best thing out for us.
And also
because it got us a very senior judge.
And also not just an outright win, because that would have been appealed. Am I correct?
An outright win would have been appealed. 100%. So our named applicant in this case, who we shall remain nameless, has already got his relief. But he held the faith. He kept the faith with us, and he said to us, "Take it further." And this is where we've ended up. This is very exciting, guys. It's a great day. It's a leap forward. It really is.
It's a good day for gun owners in South Africa.
Good day for gun ownership in South Africa.
And for our constitutional rights. Even further, it's our human rights.
I was speaking to a senior police officer this morning, and I was saying to him, I can't understand why the state wants to oppose this, because this is good for them too. Because it will take them off the hook with printing of license cards.
Yeah.
It will mean that they're not under pressure to print license cards, which they can't afford to do, or which they don't do on time. Yeah. So this will help them out too. It's a way of helping everybody out. It shouldn't be opposed, but there we have it. Guys, thank you very much for tuning in.
And thank you for supporting GOSA.
Thanks all.
See you on Friday.
Bye.
Cheers.